were looking at, and I had an argument with respect to that analogy to the certified convictions.
All right.
Your Honor.
Yes, sir.
And good morning, Your Honor. Good morning, everyone. I did send a proposed jury instruction to this honorable court.
Okay.
But
I guess
if-
they haven't been forwarded on, maybe?
I mean, I could do that. I just don't, I usually do it to the honorable
No, I
court.
understand. You know what? She just sent it, so, okay, I'll take a look at those.
And I think that Mr. Abadi had some as well that he sent. I'll forward it to you.
Okay, yeah, I haven't gotten that, but I'm sure if it just came this morning, Ms. Percival will forward it on.
Could you read Brian just?
All right, and Ms. Leva, if you want to present your argument, go ahead.
Thank you, Judge. My understanding was that we were discussing the admissibility of a certified conviction for a non-testifying co-defendant. And of course, the court is aware that 24-803-22 allows for the judgment of a previous conviction, specifically evidence of a final judgment entered after a trial or upon a plea of guilty, adjudging a person guilty of a crime punishable by imprisonment in excess of 1 year to prove any fact essential to sustain the judgment. And this includes judgments against the defendant for whom the conviction is being offered, but not the other co-defendants, shall not be excluded by the hearsay rule, regardless of whether the declarant is available. That's 24-803-22. The prohibition in that statute is that it can't be used against the other co-defendants. And that is analogous, Your Honor, to a statement given to the police by a non-testifying co-defendant. That would be hearsay and would violate the confrontation clause of the other defendants. And so the way that the courts have dealt with those issues is that a limiting instruction, much like the one that I believe we presented to the court with respect to Shannon Stillwell's statement, has been given to the jury. And if we've not, my apologies, it was my understanding that we had. And that is what I'm forwarding to the court from Mr. Abate. Your Honor, also, as the court is aware, by way of analogy, I'm going to set the next example up. Overt acts are not necessarily even crimes. They don't need to be crimes in order to be overt acts that are said to further the conspiracy. Any overt act that has been committed by a non-testifying co-defendant, if we are to say that the unavailability of the person who is committing the act makes it a confrontation clause issue for any other defendants, then we would not be able to use overt acts in a conspiracy case against anyone. But of course, that's nonsensical. So what we do with respect to statements that do violate the confrontation clause or convictions of one defendant is that we give a limiting instruction, Your Honor. And so I would say that a limiting instruction and given 24-803-22 would suffice to allow us to introduce the certified conviction for Rodelius Ryan's murder. And I hope that I have not come in too fast and made no sense to the court.
Now I follow you. Okay, well, when I get the limiting instruction from the state, I'll take a look at that and the one submitted by Mr. Steele, because clearly that's what needs to be correct, because it's a complicated situation here. Does anybody else want to be heard on that issue?
Get on my Lexus to see the statue. I'm having a little connectivity, slow internet issue.
It's slow, all right. I'm having the same issue. Good morning.
Hey, good morning, Your Honor. Good morning, Ms. Winfrey. How you doing, sir? Thank you for that stuff. I thought I was waiting on the court. Your Honor, and I did as you ordered, or requested, or suggested, whatever. And I worked on it a lot, and I hope it's helpful to the court. But I'd also like the court to take